What's up, guys? Hey, it's Clint Coons here, and in this video, we're going to be talking about creative strategies for structuring your duplexes, your quads, and more. All right, let's get started. So here's what happens. I get people that contact me all the time, and they say, Clint, I want to buy a duplex or I want to buy a quad, but I'm really concerned about how do I protect it? Because when I went to my local attorney, the attorney said, if I buy this duplex right here, since it's on one tax parcel, I have to take title to the entire structure in one entity. So let's assume that you're setting up a limited liability company, that you'll take title to the duplex in this LLC. I mean, just think, maybe this isn't a duplex, maybe it's a quad. And so now you've got basically 4 units held by this one limited liability company. So what should we do then to provide protection? Because obviously the concern when you're using a structure like this is that in this unit right here, you've got 2 tenants, and this one right here, maybe you have 1 tenant, and this one here, you've got 3 people living in this one, it's a commune. And in this one over here, we got 1 guy right there. So we have a total of 3, 5, 6, 7 different potential litigants on this one property. And if you take that property, as most people will tell you, and you deed it into this limited liability company, then if any one of those individuals decide to sue you, and it doesn't have to be them, it could be they have people over that come over to the duplex and then they're hurt. Then you get sued by one of their guests. They're going to sue the limited liability company, and since the liability company owns the entire thing, well, you know how that's going to go. Basically, bye-bye LLC and bye-bye property. And so now you could potentially lose the entire investment. So what do we want to do then? We need to think outside of the box, right? When you purchase a property like that, so let's say we have this property here and it's a triplex. So I've got 3 units here, right? 3 separate doors to my triplex. So when I buy this, right, each unit has its own separate address. So this is 221, this one's 222, and this one's 223 on Broadway Street. So if I want to protect those separate units, what you might consider doing is creating a situation where you enter into a tenant in common agreement with your own entities. Now, I recently did this for someone in Texas. What we did is we set up a series limited liability company. Now, this only works in your state if they recognize the series LLC. So I set up a series LLC, and then I created 3 cells. I mean, this is an awesome plan if you live in a state that recognizes the series limited liability company. Otherwise, I'll show you what you have to do. And so then I had each of the cells owned by the parent, just like this. So none of this stuff has to file any tax returns. And then I had the property itself. I deeded the property to all 3 cells, but I did so as a tenant in common. So so what we had is what's called a tenant in common agreement. So the property on title, what happens is that this piece of property now would show cell number 1, cell number 2, and cell number 3. So we list them all out, hold title to this property as tenants in common. So we list all that out, that this all owns it as tenants in common. Now, when we deed the property into the various cells, what we're doing on that deed, because there's only one legal description, right, when you prepare the deed, what I'm doing is at the bottom of the deed, I put a parenthetical notation. And what that means is I just put a clause in there that states that although this is a tenant in common relationship, this LLC right here holds title to this address, this piece of the property. Because I don't have a separate legal for it, so I can't break it out. But I'm putting anyone who looks up title here on notice that this LLC owns this property or this unit right here. This one would show 222 and this one would show 223. So it lists it right out on the deed. Now, why am I doing that? Because if somebody gets hurt in this unit right here on 221 and they want to bring a claim, I don't want them suing. I mean, they could try to sue all 3 LLCs, all 3 owners of the property. But what I want to do is direct the court to the fact that this unit right here is only owned by this entity right here. So if they sued here, claim rests here, and if they're successful and they get a huge judgment against me, then in my triplex, I possibly lose this unit to a creditor over here. But I still hold on to my other 2 units here because we put the world on notice that this unit is held here, this unit is held here, and they're not part of that, of owning this, because we've broken it out that way. Now, that's one way to do this. And if you want to put a little more protection into this, when I say it's a tenant in common relationship, or this is treated as a TIC, what I'm also going to do is file a TIC agreement. I'm going to have a TIC agreement that gets recorded against the property between all 3 of these LLCs. So there's an additional recording that you can make of this agreement that you create between these owners, these joint owners of this property, tenants in common, that states what the relationship is, that this tenant in common holds this interest, this one holds this interest, this one holds this interest. And the reason we're doing that is that I want people, again, to know, under unknown certain circumstances, which property is held by which company. And in addition to that, we put in there an agreement that if you're an owner in one of these units, you do not have a right to partition. Now, that's key. Whenever you hold property with someone else, you want to make sure that there's an agreement recorded against the property, tenant in common agreement, that states no owner of this property can move to partition. And what does partition mean? Partition means that you can move, when I say move, you go to court and you ask the judge to equitably divide the property. Hey, I own 1/3 of this, Your Honor, and can you carve off my 1/3 ownership so I can do whatever I want with it? Now, here's the problem. Whenever a judge were to look at this and they appoint a master or someone to oversee this to determine whether or not it can be equitably partitioned, obviously they're going to come back and say, hey, this is one structure. We can't just carve off one unit. So then what happens when the judge is told we cannot break this apart because of the property and the way it's titled, they'll say this, okay, sell it and distribute out the proceeds. So that's a way for a creditor to come in here. Maybe they're successful, they become the owner of this interest right here, and it doesn't get them paid, but they want to get paid. So what they'll do then is move for an equitable partition action to get the judge to force the sale of this property. They can do that. I've done this before in a situation with an inheritance. So by filing that TIC agreement and recording against the property, it states that whoever owns this interest cannot do that, and they're bound by the TIC agreement. So it stops that back-end maneuver that attorneys will play in a situation like this to put them in that financial position that they're hoping for. But really the reality of the situation is that when you layer it up this way, okay, let's say this was $1 million piece of property. By layering it up this way, it discourages that type of BS. That when attorneys see this and they realize the length of the structuring that you've gone through, they're going to look for policy limits, and that's what I want them to do, and or accept if it goes beyond policy limits, a much smaller recovery amount. Recently, I was working with a client, $1.7 million judgment was entered against him. Now, when he went into supplemental proceedings, the debtor's exam, and the plaintiff's counsel found out the way we had structured this particular client, and I mean, he made a big investment. He put up some complicated stuff. We did this for him. They immediately came down to $500,000. From 1.7 they were awarded down to 500,000. And it ultimately settled for less than 500. That's what good structuring can do for you if you set yourself up the right way. This is one way to handle those larger deals, quads, sixplexes, things like that, where it's on one parcel, but you realize you want the protection. Oh, by the way, I didn't mention, if you're not in a series LLC state, what do you do then? Well, if it's a good sized property, what I would do is I would create 3 separate LLCs, just like this. We got to make sure that we got our holding company, down here as follows, boom, 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 and then this would own it, just like I did with the sale. So that's if you don't have property in the series LLC state, that's the way you're going to go right there. But guys, there's ways to structure this stuff. You just have to know how to do it. Many times the local person that you talk to is going to tell you, it can't be done. It's just because they don't think outside of the box. Hey, I hope you got some great information out of this video. If you like it, be sure to hit the like button and stay tuned because I got a lot of great content coming up this year for you. And be sure to check out my YouTube lives. About every other week, every couple of weeks now, I'm going to be running a YouTube live event on Thursday on different topics so you can get your questions answered, making that available to you to bring it a little more interactive and also to get me ideas on to create more great content like this. Take care.